The Supreme Court of India has now begun final hearings in the long-running Sabarimala case. A 9-judge bench led by Chief Justice Surya Kant is hearing a batch of petitions that go beyond just one temple. At the core, the court is looking at a much larger question. To what extent can courts intervene in matters of religion? And what exactly counts as an essential religious practice under Article 25 of the Constitution? The case also deals with alleged discrimination against women at places of worship, including the Sabarimala temple. The union government has told the court that giving a strict definition to terms like religious denomination or essential practice could limit the diversity of Hindu traditions, which vary across regions and communities. So what is this case really about, and how did it get here? The issue of women's entry into Sabarimala has a legal history of over 3 decades. In 1990, a petition was filed by S. Mahendran in the Kerala High Court, seeking to restrict the entry of women of a certain age group. A year later, on April 5, 1991, the High Court upheld the practice, effectively barring women between the ages of 10 and 50 from entering the temple. The matter reached the Supreme Court much later in 2006, when the Indian Young Lawyers Association filed a petition challenging this restriction. Over the years, the case gathered political and social attention, with the then Kerala government also supporting women's entry. The turning point came in 2018. In September that year, a 5-judge constitution bench of the Supreme Court, in a 4-1 verdict, struck down the ban. The court held that preventing women of menstruating age from entering the temple was unconstitutional and amounted to gender discrimination. The judgment said that such a practice violated the fundamental rights of women. However, this verdict led to widespread protests in Kerala. Many argued that the restriction was part of long-standing religious customs associated with the temple. And then something significant happened. On January 2, 2019, 96 days after the judgment, 2 women entered the temple. Bindu Hariharan, an assistant professor at the School of Legal Studies at Kannur University, and Kanaka Durga, a Kerala government employee, became the first women to do so after the verdict. Soon after, review petitions were filed. In 2019, another 5-judge bench, led by then Chief Justice Ranjan Gogoi, did not immediately decide on the review. Instead, it referred the matter to a larger bench. And importantly, the court expanded the scope of the case. It was no longer just about Sabarimala. The court decided to examine broader constitutional questions. These included whether courts should decide what counts as an essential religious practice, and how far judicial review can go in matters of faith. That is how the case reached a 9-judge bench. Now, in 2026, the court has begun hearing these issues in detail. Hearings started on April 7, 2026. Petitioners are being heard from April 7th to April 9th. Those opposing them will present arguments from April 14th to April 16th. Rejoinder submissions are scheduled for April 21st, followed by final submissions from the amicus curiae on April 22nd. The court has indicated it intends to complete the hearings by the end of April. What makes this hearing significant is that it may not directly decide whether women can enter Sabarimala. Instead, it is expected to settle the legal principles that will guide such questions. In simple terms, the court is trying to answer this. When a religious practice is challenged, who decides if it is essential to that religion? And can constitutional values like equality override such practices?